We're in law school together. How many years ago? That was 2008.
That's about 13, 14 years ago.
So we had a matter together, and in 3 months, actually 2 court sitting, we were able to settle. And today we entered terms of settlement.
Wow.
Isn't it amazing?
Yes, it is. Even me, just 2 cities. Wow.
So now I'm going to ask you, why do you think we're able to settle this matter?
Okay, first let me say I owe you to your disposition. You are a conscionable person. I'm not trying to eulogize you, but I'm trying to describe the person you have become. First of all, I realize now that, although I've always known, but it occurred to me again that the quality of the lawyer, the conscience of the lawyer, the disposition of the lawyer, and his ego, all these 3 factors have a lot to do with whether clients can settle amicably or otherwise. Most times, lawyers' ego has a way of creeping into litigants' matters. As a result, it may not be, you discover that the focus is not actually on the merit or the compromise of the matter itself, but of who, as between both lawyers, is more competent, knows the law better, or speaks better grammar and all of that. So we're able to, in record 3 months, wow, this matter was able to get settled because, for me, from my point of view, because of your disposition. Like I mentioned earlier off record, there were times you practically pampered me when I said, no, this is unreasonable, this cannot be. You said, no, look at what is doable. They could have done better, but this is what they can do. What is humanly doable under the circumstances. And I looked at it, I felt, well, what is it? What is it? I had to go and talk to our clients. So, in a nutshell, the point I'm making is that settlements, ADRO particularly, has to do with basically lawyers' disposition. I mean, both lawyers' disposition to or towards the matter.
Wow.
That's what I can say.
Wow, thank you so much. So, in other words, lawyers should put their ego aside and focus on the client.
Yes.
Look at what is practicable.
Yes.
It's not about the law thing, but about what is realistic and what is in the best interest of
that's
your
the point.
client. Would you advise people generally in terms of mediation, or like this one, we didn't even have a third neutral, just the counsel? What would you advise people? Would you advise people to explore settlements other than just war litigation thing? What would you advise?
Okay, great. For me, for instance, my advice is, first of all, when there is a dispute, parties should reach out to each other first, as a first step, either orally and subsequently in writing by a mail or something. If that doesn't work out, they should engage a conscionable lawyer who is actually out to solve the client's problem. Yes, not to protract the matter to Supreme Court to get a title, senior title, or to take the matter to court of appeal so that he can. No, not a lawyer who wants to win the case at all cost. You can win, you can lose and win. It's possible to lose and win.
Can you explain that further, please?
For instance, there are times that you don't need to have a victory pronouncement. I know an example is this case. We don't need to have a victory pronouncement and the court said, okay, you have, I now give judgment against you, I give judgment in your favor, so and so. No. You can meet midway. For instance, in this particular case, I know that in moments from now, like our client, he can begin to turn the money around in a manner that if we had gone through the whole hog of litigation, in a year or two, we would have still been in court. But I can tell you, in a year or two, my client would have turned this money over in even more than 100%. He would have made much more. For instance, I mean, using this particular example. So it's possible it may appear as if you may not have gotten everything. You may feel like a loss, like I could have gotten interest, I could have gotten whatever. But the winning is that you got your money timelessly. You got your money without acrimony. And you know that the longer a lawyer you engage a lawyer, the much more money it will cost you. I am not saying you don't engage a lawyer. What I am simply saying is that engage a conscionable lawyer, a lawyer that knows, who has empathy for the client, a lawyer who will listen to you and proffer solutions. Of course, those lawyers are also expensive, I must say. They don't come easy.
But you get value for your money.
Yes, that's what I can say.
Thank you, Solomon. You just heard Solomon telling you that it is not about war all the time.
Yes.
It's good you explore amicable resolution.
Yes.
Call yourself before you fight it. The fact that somebody approach you for settlement does not mean that they are weak or they don't know the law, but they are thinking about you. They are forward-thinking individuals. Yesterday, I was in a court and a tenant had been living in a property in Ikoyi since 2014. She had not been paying rent.
That's serious.
The landlord went to court and the matter is still dragging. Yes, you wonder that why was the woman staying in the property? Why is she still staying in the property? She said she developed a property. I mean, she repaired a property. Yes, the landlord is right that I did not ask you to renovate my property. I did not ask you to put any money there, so get out of my house. But the tenant has been there 2014 and has not been paying. What do you think they can do in that circumstance? They could have resolved it amicably. Okay, how much did you spend?
Yes.
Let me give you something. It's not because you're weak, but if you look at the time value of money, yes, you may get judgment. The vehicle of justice is slow. Yes, it will arrive at the destination, but at the point of arriving at the destination, what's the time value of that money you're pursuing? What's the victory worth to you? So think about it. Don't always think that amicable resolution is for the weakling. No, it's for the smart and forward-thinking people. Thank you for coming around, and bye.
Thank you.